30 calendar, except for the one case we passed, going to our 1400 Puna traffic 30 calendar, except for the one case we passed, going to our 1400 Puna traffic calendar at number 1 for Philip Bikle.
Mr. Bikle, come forward, please. We're here on the motion that the defendant filed. You also have a motion on here for some discovery, apparently. Were you able to purchase the CD that you requested?
I have not purchased that. I was actually contemplating going above for a writ of mandamus, as the language of the law indicates, contrary to what was conveyed to me.
All right. Well, do you want to do that before we hear the motion?
I mean,
if you're going to do it, it may make some difference on how the motion is perceived or evidence you have. I don't know.
It shouldn't. I would like an entire record, but the last time I was here, you had rescheduled things for today because there wasn't any time for things. I just wanted a complete record. That's all. I don't believe that it will have any effect on the motions.
Okay. Well, I've read your motion and the opposition provided for by the state. Is there anything further or anything else that you need to add other than what's in your motion? You've pretty extensive, quite frankly.
Yes, the prosecution actually completely failed to address the issue of valid service of process, and in my brief, that was laid out in paragraph 8 and paragraph 9, paragraph 11, and 13 in particular. I mean, it shouldn't be a issue of clarity for them. It's spelled out. I included the judicial notice number 3, which has the self-authenticating piece of evidence for the Hawaii revised penal procedure, Rule 9, which lays out the actual process for obtaining the appearance of a defendant. And again, the prosecution in their response has absolutely nothing commenting on this whatsoever. And as it should be well known, to establish the jurisdiction of the court, you need the subject matter jurisdiction to be proper for the court, the scope, which it would be in this case if somebody authorized to represent the people of the state of Hawaii had filed a complaint, and that's a separate issue I'd like to come back to. But that particular thing would then need to be served on me, which it wasn't, and they make no indication that they attempted to. And I've included those 2 letters. The one was dated December 9th. That was the second letter to them. And the other was dated November 28th. And both of them inquired as to whether or not they were going to initiate prosecution, and if so, who were the prosecuting attorneys so that I could communicate with them on the matter. And the letters, are you familiar with them? Is that something you can recall right now, or should I
No, I have
discuss that?
I have the documents that you filed with the court. I don't have any correspondence between yourself and the prosecuting attorney.
All right, well, that should have been attached to the back of the motion to dismiss for lack of all jurisdiction. I have a copy here I can let you look at. It's a certified copy by the court clerk. Would you like to take a look at that? I'll need this back, though, because I thought you guys had all of that since I filed it.
Hang on a minute.
Okay. The very first letter would be found after page 10, where I verified the motion to dismiss.
I have letters here, yes, thank you.
Okay. All right, so again, in these letters, I actually explicitly indicated that I wanted to know if they were going to initiate prosecution and who to communicate with regarding requests for discovery material, if not them. And I offered some presumptions, which I told them, if they're busy and they can't respond, please just correct me. Let me know, where I need to be corrected here. And they didn't respond to either of these two letters indicating any interest in prosecuting the citations. And again, giving me the name of anybody there to communicate with on that specific matter.
Okay. I understand what you're saying.
Okay, so there's a failure there to indicate who that has a license has initiated prosecution on behalf of the people of the state of Hawaii, because Officer Davies is not licensed to do so, and they do not touch that in their opposition. So, that's an issue with the invoking the jurisdiction of the court for the case. And again, the follow-up is the valid service of process, which is standard procedure across the U.S. And again, there's absolutely no comment whatsoever. And those are the two main points.
All right, I'll hear from the prosecutor.
Your Honor, the state would argue that the citation issued by Sergeant Davies in this matter does constitute a complaint and summons under Hawaii Statute 803-6, which does provide that a police officer may issue a citation in lieu of a written complaint,
right,
as long as the citation contains certain information such as the nature of the charge, the time that the charge will be initially heard.
I object to this.
No, you're out of turn. You're out of turn. This is not an evidentiary hearing.
I apologize.
I would just argue, Judge, that based on that rule, that the state did comply with notice requirements for Mr. Bikle. He did receive the two citations issued on the date of the offense and did sign those citations.
Okay. And anything further?
Those two pieces of evidence there were acquired unlawfully by Officer Davies when he conducted an unlawful seizure of my person and my property under the pretense of no license plates. And in the state of Hawaii, no license plates is a violation. It's not a crime. Now, the Section 803-5 for warrantless arrest, which gives him the authority to stop somebody if he believes that there's probable cause for a crime.
You see, but what we're here for today is a motion to dismiss based upon jurisdiction. We're not here on a motion to suppress evidence. Because that's the motion that's before the court.
If he didn't have jurisdiction to pull me over, he didn't have jurisdiction to issue those citations, and those citations cannot be used to invoke.
Jurisdiction is used in a very, very different sense, quite frankly. Jurisdiction is the power or the authority of the court to exercise its power, okay? And
I would object. It has multiple meanings,
okay,
and I agree with that,
right,
but that's not the meaning that's being argued here. The meaning that I'm arguing has been laid out in law that the court has to have that power invoked. That's what we're dealing with, the invocation of that power. So I'm familiar with the fact that you have a scope of duties, and as long as you work within those duties, everything's fine. But those duties are only invoked by following the lawful process, which is what I'm arguing has not occurred.
Okay. I understand. I've read your motion in its entirety. I've read the opposition, and I'm prepared to rule. All right? I'm ruling that the citations which were issued by the officer are summons for you to appear in court, and that is what starts the jurisdiction of the court to exercise its power against you. I'm not going to argue with you, okay? This is the findings of the court, okay? And that's what the findings of the court. And so we're properly before this court for 2 citations for no driver's license and no insurance. Now, if you have other motions to file, for example, motions to suppress evidence based upon an unlawful search and seizure, that's a separate motion.
I'm still going to object to this ruling because the officer is not a clerk of court, and only a clerk of court under Rule 9 of the Hawaii Revised Penal Procedure is permitted to issue a summons, and the form of the summons indicates clearly that the summons has to be signed by the clerk of court. He's not a clerk of court. He works in a different branch of government. He works under the executive. The clerk of court works under the judiciary, and that's a violation of the separation of powers to deem this that the state witness is also the state prosecutor and also the clerk issuing the alleged summons. And the notice had been filed in the court before it was given to me.
All right, that's the process that is filed in the state of Hawaii is that when the summons is issued, that's sufficient summons for you to come to court. So I'm denying your motion to dismiss. If you want to appeal this ruling, you're perfectly welcome to do so. You have 30 days to file your notice of appeal. And if you file your notice of appeal, that will stay these proceedings pending that, unless you want to proceed to trial.
Oh, I'm going to appeal this. That's very clearly written out. I've already been through this in California once.
Okay.
And I took 4 appearances before the judge agreed with me finally.
All right.
She needed an empty courtroom to do it, though. So, I don't know how it goes.
I understand.
I do what I have to do. You do what you have to do.
I understand. Very good. Motion to dismiss is denied. Should we set this matter for trial?
I would object. I would like to enter a motion to suppress before.
Well, we can, if you want to file a motion to suppress, please do. But I'm going to set it for trial. If you set your motion to suppress, then that will stay the proceedings. And then if you file an appeal, you can make a motion to stay these proceedings pending the appeal as well. I want to make sure that nobody loses anything in this. You too. All right. So we'll set a trial date. Let's Rule 48.
July 26th, Your Honor.
So we got to set a trial date before July 26th. And we can set a motion. If you file a motion, we'll set a date for the hearing on the motion. Or if you file your appeal, then we can stay these proceedings. If you make a motion to stay them pending the appeal. June 15th, 2016 at 2 p.m. for trial.
Could I ask, Your Honor, that we have the same date for the hearing on the motion and the trial?
That's
I'll
fine.
object to that.
Okay.
Right, we can do the motion ahead of time, that's fine. Just ask for a separate hearing date on that. All right, if you file your motion to, your appeal, then we can make a motion, you can also make a motion to stay these proceedings pending the appeal.